School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 6 Business and Sustainability Unit 13 Competition Law Part 1.
After completing this unit, you should be able to understand the objectives of competition law and brief historical overview of Indian competition law. Describe Monopolies and Restrictive Trade Practices Act 1969 and Competition Act 2002. Appreciate different anti-competitive agreements and vertical agreements and explain the different enforcement authorities of competition law. Introduction. Competition law, which is also referred to as antitrust law in some jurisdictions, plays a pivotal role in ensuring smooth functioning of a dynamic market economy. Competition law takes diverse measures and approaches for ensuring fair competition among firms, which in turn can augment customer welfare by offering quality products at lowest possible prices. Fair competition in markets is important for all, be it the consumers, the competing firms, and the economy. Objectives of competition law. Competition law concerns itself with firms enjoying undisputed market power, which opens up the possibility of hindering consumer welfare by increasing prices, reducing output, diminishing product quality, and suppressing innovation. Competition law also keeps a check on the possibility of business firms from colluding with each other, affecting the supply of a product or a service, thereby proving detrimental for the consumers. The basic assumption is that markets populated by a few participants may prove to be less competitive than markets housing multiple participants, as oligopolistic and monopolistic enterprises can exert their dominance to hinder the entry of new participants. Brief historical overview of Indian competition law. The Indian Constitution has been drafted carefully with several measures aimed at safeguarding diverse rights that can contribute to the flourishing of the country as well as its citizens. Articles 38 and 39, though having been placed in Part 4 of the Constitution as directive principles of state policy and unenforceable in a court of law, have proven extremely significant in laying down directions for good governance of a state. They direct the state to frame policies for ensuring that the ownership and control of the material resources are adequately distributed and that the operation of the economic system does not lead to a concentration of wealth to the common detriment. The first phase of market regulation in India began in 1950-51, which was characterized by an increased reliance on the government to take the initiative in economic activities. Also known as the closed economy model, policies at that time were less focused on ensuring competition and more on the prevention of concentration of economic power. The Government of India ordered the formation of a committee, the Mahalanobis Committee, to assess the income distribution in the society owing to rising monopolistic and restrictive trade practices in the country. This led to the formation of the Monopolies Inquiry Committee, and the report submitted by the former paved the way for the Monopolies and Restrictive Trade Practices Act 1969 or MRTP Act. This way, the Constitution of India, specifically Article 39, sowed the seeds for the genesis of competition laws in India. Monopolies and Restrictive Trade Practices Act 1969. The MRTP Act was enacted to control monopolies to ensure that the economic system does not culminate in concentration of economic power and to disallow monopolistic and restrictive trade practices. What highlighted the second phase, ranging from 1991 to present, was bringing forth market-oriented economic policies with the coming of the new economic policy or NEP that needed to be in tune with the rise of globalization, liberalization, and privatization policies. These policies led to de-licensing and deregulation of sectors that were priorly under the control of the public sector. Industrial activities which were exclusively operated by the public sector were opened up for entry by the private sector. The MRTP Act was observed to be incompatible with this shift in industrial policies which focused on competition and market orientation. Thus arose the need for a regulator which could facilitate market functioning in accordance with the country's changing industrial policies. Raghavan Committee Report. The call seeking a shift of focus from restraining monopolies to the promotion of competition was one of the primary reasons for the MRTP Act becoming obsolete, thereby paving way for a new legislation. What ensued was the appointment of a high-level committee on competition policy and law in 1999, often referred to as the Raghavan Committee. The committee was responsible for providing suggestions for the establishment of a suitable legislative framework for competition law and recommended changes in relation to restrictive trade practices. The committee, in its final report submitted to the government in May 2000, highlighted the need for a competition policy to attain efficient allocation of resources, to regulate concentration of economic power, and to promote consumer welfare. It was submitted that competition policy has its primary economic goal as the preservation and promotion of competition, which can further contribute in making the process of production and allocation of goods structured and more efficient. The committee pressed on the need to balance the conflict between the existing government policies and the competition policy and highlighted the requirement for a law and a law enforcement authority in the form of Competition Act and Competition Commission of India, referred to as CCI or Commission hereinafter, respectively. Competition Act 2002. The Competition Act was enacted in 2002 based on the recommendations of the Raghavan Committee for ensuring fair competition and ushering economic development in the country. The primary aim of this piece of legislation is to avert practices having anti-competitive effects for the advancement of competition in the markets, to safeguard the interest of the consumers and to guarantee freedom of trade to the market participants. This legislation is the successor to Monopolies and Restrictive Trade Practices Act 1961. The Act lays down provisions relating to horizontal and vertical anti-competitive agreements having an adverse effect on competition, prohibition of abuse of dominance, and rules for combinations and their regulation. The Competition Act also contains certain provisions to promote competition advocacy. Anti-competitive agreements. Agreements entered between enterprises, persons, or association of enterprises or persons in pursuance of production, distribution, supply, storage, or control of products or services which have a tendency to result in appreciable adverse effect on competition, that is AAEC, within the jurisdiction are referred to as anti-competitive agreements, and they shall be declared void. To determine if an agreement has an appreciable adverse effect on competition, the Commission shall have due regard to factors including creation of barriers to new entrants, driving off existing competitors, foreclosure of competition by hindering entry, improvement of production or distribution of goods, etc. In a competitive market setup, firms vying for the business or the consumers are supposed to compete with one another, not collude and cooperate to alter the process of competition. Cartels are horizontal agreements made for the purpose of market allocation, price fixing, output restriction, and the submission of collusive tenders to rig the outcome of competitive tenders. These are some of the techniques employed by conniving firms to distort competition. Under the Competition Act 2002, Section 2, Clause C, puts forth an inclusive definition of cartel as, and I quote, an association of producers, sellers, distributors, traders, or service providers who by agreement amongst themselves limit, control, or attempt to control the production, distribution, sale, or price of, or trade in goods or provision of services, unquote. In the cartelization by public sector insurance companies case, the CCI took suo motu cognizance to investigate if 4 public sector insurance companies had formed a cartel and engaged in bid rigging in response to a tender issued by the Kerala government. Rejecting the argument of the insurance companies that they formed a single economic entity and were thus subject to the control of the central government, the CCI held that the submission of separate bids by the companies for the tender, along with the resolution regarding determination of bid amounts being taken voluntarily through an internal meeting without the supervision by the Finance Ministry, proved the contrary. Based on the business sharing agreement and the evidence of the opposite parties having met one day before the submission of tender, the CCI held that there was a conclusive proof of bid rigging and collusive bidding by the opposite parties or OPs, satisfying the requirements for contravention under Section 3, Clause 3D of the Competition Act. An agreement entered or decision taken amongst enterprises, persons, association of enterprises, or persons, or between a person and an enterprise, including cartels, shall be presumed to have an appreciable adverse effect on competition and shall be considered anti-competitive per se if they result in number 1. Determination of sale prices. The competition regulatory framework not only concerns itself with blatant price fixing, but also agreements having an effect on suppressing price competition. In other words, the act of price fixing does not just encompass the final price, but also instances having an indirect impact on the final price. Reducing price competition by agreeing not to offer discounts, making use of an open information scheme, and charging uniform delivered prices may also be instances of price fixing. Market participants forming a cartel, agreeing to offer identical discounts, and applying the same in the downstream market was also held to be another facet of price fixing and declared to be anti-competitive in nature. Number 2. Output control. An agreement among firms to control or limit production, supply, technical progress, markets, or provision of goods and services shall be presumed to be anti-competitive. The CCI generally focuses on factors such as production capacity, capacity utilization of the competitors, demand for the product in question to decipher any patterns of output control for the concerned product. In the cement cartel case, the Commission found evidences regarding the formation of understanding and agreement among the opposite parties or OPs via the Cement Manufacturing Association or CMA for communicating and information sharing in relation to manufacture of cement. The Commission also unearthed low capacity utilization leading to controlled supply of cement by the companies, which was in clear contravention of Section 3, Clause 3b of the Competition Act. The Commission opined that limiting the supplies of cement over the course of years and giving rise to shortages had led to an upward demand, resulting in a hike in prices thereafter. In the absence of any efficiency or improvement in manufacture, owing to the coordinated behavior of the cement manufacturing companies, the OPs were held to have formed a cartel. Recently, the CCI passed a final order against three beer companies, viz. United Breweries Limited, SAB Miller India Limited, renamed as Anheuser-Busch InBev India Limited, and Carlsberg India Private Limited for forming a cartel and selling beer in many states and union territories in conjunction with the All India Brewers Association. The cartel had engaged in price parallelism, which was in contravention of Section 3, Clause 3a of the Competition Act 2002. Number 3. Market allocation. Competition may also be threatened by an agreement between the firms to apportion segments of market amongst themselves to be handled exclusively by each seller such that they no longer have to compete with each other. When the participating firms concur to share particular markets based on geographical area, classes of customers, or on the basis of the product, such agreements may be referred to as horizontal market sharing agreements. In HFB Holding versus Commission, the opposite parties were penalized for forming a cartel and indulging in sharing of the entire European market among themselves. They further engaged in acts to hinder the only substantial competitor not forming a part of the cartel, driving it away from the concerned market. And number 4, bid rigging or collusive bidding. Agreements capable of lessening or wiping off competition for bids or which have the effect of manipulating the process of bidding are held to be anti-competitive per se. Bid rigging or collusive tendering is said to occur when competitive bidders decide not to compete genuinely or endeavor to secretly influence the outcome of a bidding process by submission of identical or cover bids. In the case of cartelization in tenders of Pune Municipal Corporation for solid waste processing, a prima facie opinion was formed by the CCI against the OPs for having engaged in the acts of bid rigging or collusive bidding, violating Section 3, Clause 3d of the Competition Act 2002. The CCI opined that bid rigging under Section 3, Clause 3D shall be presumed to have an adverse effect on the competition irrespective of the purpose or duration of the cartel, and it is immaterial if the act culminated in a benefit being accrued from the cartelization. The CCI also held that so long as a subset of bidders are found rigging the bidding process by colluding, the onus shall shift on the OPs to rebut the presumption of having caused an AAEC. Disagreeing with the contention of the OPs that the latter were engaged in different business activities at the time of the bidding process and thus not amenable under Section 3, the Commission held that the activity for which bidding was held and in pursuance of which the alleged violation of law took place is what proves significant in determination of cartels. Vertical agreements. Vertical agreements are agreements between persons or enterprises at different levels of the production chain in distinct markets in relation to production, distribution, supply, storage, or price of goods or provision of services. Unlike horizontal agreements, vertical agreements are not anti-competitive per se, and it needs to be established that the alleged activity has caused an appreciable adverse effect on competition, that is AAEC, in the country. Vertical agreements also comprise: Number 1. Tie-in arrangement. Tying is the practice of supplying a product, the tying product, while also making the buyer purchase a second product known as the tied product. Tying may be employed by a dominant firm for increasing the sales of the tied product in the market by leveraging its position with respect to the tying product, leading to a horizontal foreclosure of market. A tie-in arrangement is detrimental for competition as a consumer is coerced into purchasing a product, that is the tied product, which she or he may not necessarily require. In Hilti AG versus Commission, Tetra Pak, a company engaged in the sale of liquid packaging machines, required customers to also buy cartons from it, further insisting that services for repair and maintenance should be provided by them. The Commission opined that sale of cartons along with the machines was not customary, with the former forming a separate market upon which Tetra Pak was trying to eliminate competition. Number 2. Exclusive supply agreement. Agreements restricting the buyer from purchasing goods or services other than those of a particular supplier are termed as exclusive supply agreements. Such agreements can also be referred to as exclusive purchasing or single branding agreements. By employing such agreements, the purchaser is barred from acquiring products from other competing sellers, defeating the process of market competition. In Jindal Steel and Power Limited versus Steel Authority of India Limited, it was alleged that the agreement between Steel Authority of India Limited, that is SAIL, and Indian Railways for exclusive supply of rails to Indian Railways was anti-competitive, resulting in foreclosure of market for new entrants including Jindal Steel. The Commission held that the exclusive arrangement between SAIL and Indian Railways was not in violation of the provisions of competition law, as only a small segment of SAIL's total sales made up the sales to Indian Railways. Also, Indian Railways required assurances for steadiness of supply of long rails, which was being offered by SAIL, with Jindal having failed to establish itself as a viable competitor to SAIL. Number 3. Exclusive distribution agreement. Agreements requiring the supplier to sell its goods to one specific distributor in a particular territory, thereby restricting the output or supply of any product, falls under the category of exclusive distribution agreements. These may diminish intra-brand competition and heighten the risk of market partitioning or market allocation for the sale of goods, facilitating price discrimination. Number 4. Refusal to deal. Refusal to deal refers to scenarios wherein restrictions are placed on persons or classes of persons to whom goods may be sold or from whom the goods may be bought. Refusal to deal agreements result in market foreclosure for new entrants, making it difficult for the latter to compete. In English, Welsh and Scottish Railway Limited versus E.ON UK plc, the railway company was fined for entering into exclusive agreements with various power stations for the carriage of coal. And number 5, resale price maintenance. Resale price maintenance occurs when a seller, mostly manufacturer, demands that the buyer, mostly retailers, should engage in resale of that good only at a price fixed by the seller, and the buyer cannot resell at prices lower than the prices suggested by the seller. In FX Enterprise Solutions India Private Limited versus Messrs. Hyundai Motor India Limited, the CCI found Hyundai Motors placing restrictions on its dealers by imposing a maximum permissible discount at which the vehicles may be sold to an end consumer. Dealers not adhering to the upper limits on discount prices were being penalized. The CCI held that the imposition of minimum resale price prevents the dealers from effectively competing on the price factor and is anti-competitive in nature. Section 3, Clause 5 of the Competition Act holds that such agreements shall not affect the rights of any person to restrain infringement or from laying down reasonable conditions imperative to protect her or his intellectual property rights, including patents, copyright, trademarks, designs, and geographical indications.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.